Good morning, everybody. I hope some of you had an opportunity to have some breakfast this morning and do a little socializing with each other and with members of the court and the Judicial Council and the Bar Association who are here today. I'm excited. This is our second continuing ed program, and I think it's going to be an excellent one. Good turnout. I will tell you that this is also being video streamed, so you can share with your colleagues who aren't here or anyone back at home who might be interested in the court system, that they can check out this presentation on the General Court's website. We will have with us today a presentation about the courts, about the New Hampshire Judicial Council. Some of you may not ever have even heard of that. And about the New Hampshire Bar Association and how that is and is not related to the court system in our state. So thank you very much for coming. I want to thank the judicial branch for the time that you're giving us and the opportunity to learn more about one of the three branches of government. And I would look forward to hearing this myself and like to introduce the Honorable Justice Linda Delanis, who is the Chief Justice of the New Hampshire Supreme Court. So thank you in helping me welcome the Chief Justice. Yes, you do stand up.
Thank you. Thank you. Thank you. Thank you, Madam Speaker, honorable members of the General Court. As I think you now know, my name is Linda Delanis. I'm the Chief Justice of the Supreme Court. And as I always feel when I'm in this room, I have a sense of awe, not only at what you all do here, but that the time and effort that it takes for you to do it, and no one appreciates that more than I do. We that is the judicial branch, thought and reached out to the Speaker about this, that it might be useful, since there's such a large group of freshmen this year, to offer a little orientation about the branch. Some of what I say no doubt will be familiar to some of you. Some of what I say may be completely new. If you've heard it before, please bear with me. And if you haven't, I hope that I don't bore you. With me this morning are Chief Justice Tina Netto of the Superior Court and Administrative Judge Ed Kelly of the Circuit Court, along with Deputy Administrative Judge David King and former legislator of the Circuit Court. And they will follow me with specifics about their courts and the things that go on in them day to day. My purpose here this morning is to tell you a little bit about what the branch has been doing over the past few years with the citizens' tax dollars. We recognized in, about 2005 perhaps, that the then current model, which was expense maintenance, budgeting every other year, add stuff to what you had before and keep on going, was not going to be sustainable in the long term. And as well, we recognized that the branch was still, by and large, a 19th century model. There are some people who would suggest that up until very recently, our dear friend behind me, Daniel Webster, would be very comfortable plunked down in a courtroom today, if that were possible. And the Supreme Court decided that we needed to try to think differently and put together a group which we came to call the Innovation Commission, which was chaired by a retired Fortune 500 business CEO. We reached out to legislators. Of course, we drew on the experience of court personnel and citizens and lawyers, and it was a large, active group that worked for about a year, and the charge that was given to that group was, if you had to start from scratch in New Hampshire and build a judicial branch, what would it look like? And the Supreme Court basically stayed out of the way because we didn't want to be seen as trying to drive the train. And at the end of that process, we took a look at what recommendations had been made, and our eyes were opened. They were really quite remarkable, and we decided, with your help, if we could get it, that we would try to reinvent the branch. And we, I am happy to say, have actually done that and are continuing to do it, and will be asking you for continued help in that regard. It used to be that the New Hampshire Judicial Branch consisted of 4 separate trial courts: the district court, the probate court, the family division, and the superior court, and as well the single appellate court, the Supreme Court, which remains the only appellate court today. What we have done is change 4 trial courts into 2 trial courts. And now we have a circuit court. And the circuit court is what used to be the district, probate, and family courts. We're all having a little bit of trouble, and we stumble over our tongues sometimes when we try to talk about the circuit court district division. You know, old habits die hard. But the transition has been rather remarkable and rather quick. The circuit court now accounts for approximately 80% of the business that is done by the judicial branch in the state. And that has given us the ability to realize economies of scale that were theretofore not possible. The biggest is that we reinvented our management structure, and at the end of a very short period of time, allowed us by the House and Senate, less than 90 days, I think, we reduced our principal managers from 52 to 18. We recreated the management scheme so that our managers are now supervising at least 8 people, right? At least 8 people, instead of, in some locations, 1 person or maybe 2 people. And we have attained the ability to deploy our judges in ways that we could never do before. And a perfect example of this is Judge King. He is the probate judge for Coos County. And when he would be in Lancaster doing probate matters on a Friday afternoon, if a local police department came in looking to arraign someone before the weekend on a criminal complaint, Judge King couldn't do that. Instead, the clerk of the district division, then district court, would have to call around, try to find a judge. I believe Judge Desjardins is the only one up there, and he wasn't always nearby. And you can just understand from that little example how completely inefficient the old system was. Now, Judge King can do that arraignment, and he can hear the family cases that come in on an emergency, and as well, all of the other circuit court judges, newly appointed and previously certified, can do the same thing. It was enormously wasteful, and it is no longer wasteful in that way, and we hope it will be completely not wasteful going forward. We had hoped to accomplish this goal through attrition. We have a remarkably loyal and hardworking workforce, but again, budgeting being what it is, we were told to accomplish the switch to the circuit court before July 1, 11. It all blurs. And we were told to do that in about March of that same year. I am not proud to have presided over a reduction in force of 72 people, but we did it. It was traumatic, and it remains a sore spot in the system because those folks, in my view, did not deserve to lose their jobs. Nonetheless, they're gone. We saved, in the first 10 months of operation of the circuit court, about $2 million that otherwise would have had to be spent. I could go on for days talking about the money that we have saved for you folks, but it would just get boring. The circuit court is operating full speed ahead. It has been a far less tumultuous transition than I expected it to be. Everyone seems to have adapted rather well, and we're extremely proud of that effort. There's something that goes along with this that's also part of our reinvention that I'm going to steal a little bit of thunder from the administrative judges about, and it is our call center. We recognize that centralization would probably be an important thing for us to look at going forward. We used to have 72 distinct courts in 43 or 4 different locations, and that in and of itself is inefficient. So what we decided to do was create a centralized operation, and we got some help from Delta Dental, I think, and Department of Safety, who had done things like this before, to create a centralized call center at which we deployed staff from the trial courts who volunteered to come to our location in Concord. We'd love to have you all see it if you haven't yet, and deal with the routine run-of-the-mill calls that come into the courts every day of the week. The average number of calls fielded by the call center now, because the circuit court is fully deployed, we rolled it out over months to make sure we caught glitches and so on, is between 2,000 and 2,600 calls per day. The call center personnel, who are specially trained, have been able to handle approximately 70% of those calls every day without having to refer the calls out to the courts. When they do have to refer the calls out to the courts, they do so in a seamless fashion. In other words, they get in touch with the person at the trial court who needs to be contacted, say, this is Mr. Citizen, his case is citizen versus other citizen, this is his question, he's on the line, I'm going to transfer him to you right now. And so Mr. Citizen is already talking to somebody who knows what his problem is, and he doesn't have to explain it all over again. Now, the clerks will tell you that the 11,000 hours of time that the call center gave back to the trial courts between January 4th and September 30 of 2012 was almost one for one, 11,000 hours of uninterrupted case processing time that we didn't have before. It's one of the principal ways by which the branch has been able to keep its head above water, literally, because the folks who are out in the trial courts now spend their days concentrating on the work that they have to process rather than being interrupted constantly by calls that someone else can easily answer. We are exceptionally proud of this effort. It's kind of the jewel in the crown at the moment. Along with that, we've also created a video conferencing system, which is not entirely up and running yet because there have been some technical issues with getting the equipment deployed statewide. But when we're done, it will be, we will have video conferencing capacity in all of the correctional facilities in the state and all of the courts in the state. And in fact, the effort has proven so popular and successful, in spite of some early misgivings, that even the Sununu Center is talking to us now about the possibility of handling some juvenile matters remotely. The sheriffs were initially skeptical. They're now our strongest supporters because they save time, they enhance public safety, they don't spend as much money on gasoline, they can use fewer deputies and bailiffs and so on and so forth. The branch itself we haven't yet been able to quantify the savings to us, but we know that the savings is out there in the municipalities and in the counties, and we're all in this together, so as far as I'm concerned, that's a good thing all by itself. In December, I think that's the last month for which I have information, we had more than 700 video hearings scheduled. And by the way, this now includes family court hearings involving inmates who used to be transported for family court hearings, but now we're handling those remotely. The judges are on board with it. We thought we might experience some resistance, but each month, and with more equipment, we are scheduling and holding more and more remote hearings, and the savings is remarkable. The biggest piece of our reinvention is a work in progress. We call it the New Hampshire eCourt project. And with your help and a small capital appropriation, we'll be asking you for more, please, we have begun our effort to electronically connect every court in the state and digitize our files so we won't have paper storage anymore, and a whole lot of other things, you know, e-fine payments, e-filing, e-noticing, everything with an E in front of it that you can think of, we are in the process of creating for you. Our proof of concept, because of some budgetary difficulties that got lost in the process last year, has changed. We were originally going to use the Superior Court as our proof of concept because the Circuit Court already had too many other things to worry about. But in the end, we didn't have enough money to do that, so instead of just crawling into a cave and licking our wounds, we came up with another plan, and we are building the infrastructure. I think of it as the plumbing, you know, the pipes that will do all of this. And on that infrastructure, the first bulb on the tree that we are going to hang is the small claims cases. Now, that might not seem like much to you, but there are roughly 14,000 of those cases filed every year in New Hampshire, impacting at least 28,000, is that right, citizens, most of whom are self-represented, and it is, in fact, among our top 5 case types in case filings. So it's much bigger than it may seem at first, even though each individual case might not have a huge monetary value. And it will allow all of the folks involved in these cases to handle their cases from home on their own computers, or at the court with the assistance of court personnel if they don't happen to have one. And the only thing that they will have to do, we're going to process all of these cases centrally as well, so the only thing that people with these disputes will have to do is show up for a hearing if they can't find a way to settle their case. And that will be a huge savings for us in terms of staff time and judge time and citizen time. The convenience for the citizens will be more than palpable. Now, the rollout for the eCourt project is going to take us, because we're basically doing it internally with very little assistance from outside consultants, and we don't have legions of staff to do this. It will take us probably another 2 biennia, assuming we can get the funding for it, maybe 2.5 biennia, but we're well on the way. In fact, we're having a public forum on that very subject next Tuesday morning at 8:30. If any of you is interested in attending, it will take 1 hour, no more, over at the AOC building where we are, and it will tell you everything that we've done to date. But if you don't feel like doing that, you can go to our website and you can click on the eCourt project link, and that will tell you everything that we've done too. It's an enormous amount of effort that nobody has been able to see so far, but we're hoping that in the late spring or early summer, because, let's see, our RFP is out. The bid deadline, if I'm right, is either today or tomorrow, and we'll be selecting our vendor within the next 60 days. So we're hoping that by this summer we will have something to show for our efforts and the citizens' dollars. There is much, much more I could tell you, but I'd like to let my colleagues give you a little more detail about what goes on in the trial courts day to day, and we would be happy when we're done to answer any questions you might have. So thank you very much.
Good morning, everyone. My name is Tina Netto, and I'm the Chief Justice of the Superior Court. It really is a pleasure to be here. And I have to say how much support I have for Chief Justice Delanus and her leadership in bringing the judicial branch into the 21st century. It's just been exciting working with her. She motivates all of us to change, and I'm looking forward to the years to come working with her in the future. What I wanted to do today is just tell you a little bit about the day in the life of a Superior Court judge, so you have some understanding of what goes on in the courtroom. I know some of you probably have a pretty good understanding, but sometimes there are things that we do that people don't always recognize as part of the job. The Superior Court jurisdiction is basically to handle all jury trials. So we have jurisdiction over felonies from serious driving offenses to homicide. We have jurisdiction over medical malpractice cases, personal injury cases, contract disputes like construction contracts, employment contracts, and major business litigation. Jury trials can take from 2 days, which is normal, up to 4 weeks for maybe a homicide. And often judges can preside over 2 or 3 jury trials per week, depending on what's on their docket. Most people believe that all we do as trial court judges in the Superior Court is to preside over jury trials, and that's really not true. We do a lot more than that. We also, a large portion of what we do involves what are bench trials. Those are basically trials without juries, and the statutes that you pass dictate what kinds of cases they might be. And some examples might be property line disputes, non-competition contracts between employer and employee. I actually had a 10-day trademark dispute, if you can believe it, over angioplasty plastic tubing, and I know a lot more about it than I ever thought I would know in my entire life. We actually need to become an expert in whatever the topic is for that particular trial and be able to resolve that dispute for the parties. If we have a bench trial, after that bench trial, we have to conduct legal research and issue a written order. And those orders can range from 5 to 25 to 30 pages in length. So the judge does not and cannot sit on the bench in the courtroom from 8 to 5 every day. Sometimes people come to the courtroom and see that it's empty and wonder, what are we doing? Are we back there having coffee? Are we chit-chatting with the staff? Usually if you see an empty courtroom, it means the judge is writing and doing research and getting the cases resolved for the parties that they heard in the previous week. All the cases we handle require involvement from the judge from the beginning to help manage the case from start to finish. So once a case is filed, there are many events that occur before the trial that need the court's assistance. So what happens during a typical day might be from 9 to 10 o'clock, a judge will conduct what we call list hearings. And it might be hearings that ensure the parties are giving each other all the documentation they need to make sure the trial is fair. It might be to resolve some disputes early about whether experts are qualified to testify. It might be to determine whether a case should be dismissed before trial without a jury. And in criminal matters, the judge conducts arraignments. That's the first appearance where the defendant is informed of what the charges are. The judge may conduct bail hearings, and the judge may accept a defendant's guilty plea to resolve a case. So those are what we call short list hearings, and there may be 5 to 7 of those hearings on a variety of cases from 9 to 10 o'clock in the morning. And after those morning hearings, then the judge would conduct the lengthy jury trials or bench trials or lengthier hearings. One of the most difficult decisions, I think, for a Superior Court judge is to decide what sentence to impose on a nonviolent drug offender. And some of you may have been able to attend the drug court presentation that we did a couple of weeks ago. And the easy answer, I think, suggested by some people is to impose a sentence that will confine the person to the state prison for the maximum time allowed by statute. That would certainly keep them off the street for a long period of time. The real question really should not be how many years should a truly drug-dependent person serve in prison, but what sentence has the best chance of returning that defendant, who will eventually be released, to life as a productive, drug-free, crime-free citizen, and what has the best chance of reducing the likelihood that that person will continue to reoffend in the community. And drug courts are one answer to that question. They've been studied across the nation for the past 20 years. And drug courts are intensive supervision where an individual comes to court weekly and is accountable to the judge for their behavior in the prior week. They receive random drug testing 3 times a week. They're in treatment 3 hours a day, 3 days a week. They are going to AA every single day. And if they don't comply, when they come to court, the judge gives them a short, swift, immediate sanction. And the evidence-based studies demonstrate that that kind of program costs less and reduces the likelihood that this person will reoffend. So it accomplishes protecting the public from further victimization at a lower cost. So I'm hoping that I'll have a chance to talk to you more about those programs and ideas in the coming years. Let me just close with a couple of my favorite stories about the judicial system. You may know about ex parte hearings. That is basically when someone can come to court without telling the other side because it's such an emergency that they need immediate relief. 10 days later, then, there's a hearing where the other side appears and the court can hear the other side of the story. So I had a case in Stratford County some time ago, and this very lovely middle-aged couple came to court. They were desperate because they were living in this home that they'd been living in for 20 years. They had these amazing, beautiful gardens, and they were all from old heritage breed plants that they had collected all across Europe. And their landlord and they were in a dispute, and the landlord was going to be evicting them, and they were very concerned that their gardens would be destroyed. So they came to court for an ex parte order from me requiring the landlord to do nothing until we could have a further hearing. And of course I granted the order. It seemed pretty clear to me. Until 10 days later, when the landlord came back to court and said they were all marijuana plants. Yeah. So, yes, it was in the paper. Yes, I was embarrassed. But the good lesson to me is no matter how convinced I am by one side of the story, there is always another side of the story. And then the last brief example I'll give to you about why I think our judicial system in this state is so strong. I had a case where a woman came to court against the city. The city wanted to widen a street in Dover, and they needed to take down this 200-year oak tree, and she would have nothing of it because it was a beautiful oak tree and it was right outside her home. And so she did what anybody reasonably would do. She climbed in the tree and she sat in it. And she would not get down out of the tree, and so the city came to court asking me to order her out of the tree. And I said, well, I need to hear from her first. I'm not going to let you cut down the tree before I hear what the story is. And she represented herself. She did her own research. She came to court and she demonstrated that because of the age of our laws, that when there's a tree without a deed or a road without a deed, whoever lives closest to the midline of the carriageway owns the tree. So she demonstrated and proved that she, in fact, owned the tree. And it took quite a period of time. The mayor thought I was just a crazy judge for letting her sit in the tree. And she eventually demonstrated she owned the tree, which means the city would either have to pay her to take it down by eminent domain or leave it there. They soon discovered they had a huge public relations nightmare on their hands, so they decided to pave around the tree, so it has its own little parking space on York Street. But that demonstrated to me that this judicial system is there for all of us, for the wealthy, for the poor, for the best of us, and for the worst of us. And so I'm happy to be part of the system, and I would welcome you at any time to call my office if you have any questions about what we do in the courts. Thank you very much.
Good morning. My name is Ed Kelly, and I'm the administrative judge of the Circuit Court. Before we got started, Chris Keating, the director of the Judicial Council, came up to Judge Netto, Judge King, and I, and said, just the high points, judges. And so it's clear that he has made the shift from practicing lawyer to director of the Judicial Council. But let me just pause for a second on Chris. If you haven't had a chance to meet Chris, please avail yourself of the opportunity. He is, in addition to being an all-around wonderful human being, an extremely competent manager, somebody who knows our system, all three branches of government, extremely well, and I think a very worthy successor to the always amazing Nina Gardner, who is now sitting in the back of the room. So please take the opportunity. I thought that what I would do, the chief really spoke a lot about the Circuit Court and some of the things that we've done. And what I wanted to take just a few minutes to do is talk about the work of the circuit court from a different perspective altogether. The two trial courts, the Superior Court and the Circuit Court, have exactly the same mission, and that is to provide access to justice to the citizens of the state. But each of us, because of our different caseload, jurisdiction, and other variations, has a different path toward providing that access to justice and are affected by different outside influences in providing that access. There are three points that I would like you to think about that I think will be helpful in trying to get a sense of what it is that is different between our courts as we achieve that single goal. The first is the volume of cases. The Chief mentioned that we handle in the Circuit Court more than 80% of the cases that are filed in the court system. Put another way, 80% of the people who come into contact with the court system are going to do it through the Circuit Court. That's a huge responsibility that we have, since most people are getting their impression of our system of justice as they come through the circuit courts. But it's also an incredible burden in terms of the work that has to be performed just in processing all of the paper and all of the work having to do with the 190,000 or so cases that come across our desks every day. 70% of those cases, and in some case types it's actually more, 70% of those cases involve at least one person who's self-represented, which brings to us not problems. I don't like to think of them as problems because that's every citizen's right, and that, by the nature of our cases, is something that commonly happens, but brings issues to us that we have to address very carefully every day. And the challenges are how to not only process those cases, but how to assure every person, including all of those self-represented people that come into our court, the time that they need to present and or defend their case. And how to make sure, particularly those thousands of self-represented citizens who come to our courts, how to assure that they fully understand the process, the law, the procedure that they have submitted themselves to by coming to court, and how to make sure that those citizens feel as though they have been heard by someone who understands their case. And importantly, how to assure that we're going to be able to move those 190,000 or so cases through our system in an efficient way and resolve those disputes just as quickly as we can. The second sort of hallmark of the circuit court that I think is helpful to keep in mind, in addition to the huge caseload, is the case types that we hear. The jurisdiction of the circuit court is established by the legislature, and I think it's fair to say that the case types that we hear are among the most, and in many cases, the most emotionally laden cases that are filed in the court system. Likely, if you have been in court, or your neighbor has, or a family member has, they've been involved in something that we are handling. Everything from a tenant eviction, which people might say isn't a big deal. Believe me, it's a big deal for someone who's being evicted because they haven't got the money to pay the rent next month. And it's a big deal for the landlord who needs that money in order to keep his or her business alive. So everything from landlord-tenant cases to child abuse and neglect cases and delinquency cases, from divorce cases to the involuntary commitment of one of our citizens at the state hospital due to mental illness, from motor vehicle cases to the termination of parental rights. And each of these cases, stalking cases, domestic violence cases, you can just get a sense, I think, if you think about the titles of those case types, the emotions and the raw feelings that come into our courthouses every day. The toll that it takes on our citizens, our fellow citizens, every day is huge. The toll that it takes on the staff who meet with these citizens, your neighbors and my neighbors, every day in our 32 locations across the counter and on the telephone, is huge on the staff. And the toll that it takes on the people who are charged with hearing these cases and doing our level best to reach a fair resolution of the issues that are being presented to us, the judges, the masters, the referees in our court system, takes a huge toll on those people as well. So I don't mean to overstate it, but I don't think there's any way to articulate it other than to try to impress upon you just the level of difficulty these cases bring, in addition to the huge caseload. The third and last thing that I wanted to just point out to you is, I think, very positive, and that is the Circuit Court's commitment to innovation and change. And that's a commitment that did not end with the end of the Innovation Commission that Chief Justice Delanus talked about. It's a commitment that stays with us each day as we look for newer and better ways to do the work that we do. I was talking with members of Division 1 of the Finance Committee the day before yesterday, and I was telling them that this change thing we have found is addictive. Once you make a change and you see that you've actually made the process more efficient and you see that you have done something different from what has been happening for the last 20 or 30 years, and the world didn't stop. In fact, it got a little bit better. It really makes you want to look for additional changes. So in addition to the call center that Judge Delanus talked about that handles 500,000 calls a year, that keeps all but 35% of those calls from going to the local courts so that people who are charged with data processing aren't interrupted dozens of times a day by a telephone call, an important telephone call from a citizen who's looking for answers. We've been able to achieve efficiencies allowing us to keep the numbers of staff that we have at or below the level that it was before we began. We also instituted, with the help of the legislature in the last biennium, a part-time evening shift. Now, the people who were business people on this Innovation Commission looked at us as though we were crazy when we were surprised at the suggestion that perhaps we have an evening shift. But in most of our larger courts now, we have a very small group of people, no more than 4, who come in and work between 4 o'clock and 8 o'clock at night and process paper. That's all they do. And we found in studies before we did it, and we found it since we have done it, that we've been able to achieve an efficiency greater than 100% over what can be accomplished during the day, because the lights are out in the courthouse. There are no judges, there are no citizens, there are no phone calls. There are 4 people doing nothing but processing paper, and they can do it with incredible efficiency. We now also have those people, working in some locations during the day in segregated places of the courthouse. We've expanded the use of part-time employees, something that was a little controversial, but what we found was, obviously, there are peaks and valleys in our workload. You know, in the call center, for example, there are days of the week that are very busy. Monday morning, the phone rings off the hook. Friday afternoon, not so much. Do we need to have a full-time staff there all the time, or does it make more sense to have part-time staff that we can deploy when the work is higher? We found that the latter is what we need to do and what we have done, not only in the call center, but around the state. The use of referees. A referee is a legally trained person who is assigned either a specific part of a case or a specific case to decide. We've been using referees to address child support modification issues. We've been using a referee to decide the involuntary emergency hearing for commitment of people to the state hospital. And soon we'll be using referees to hear small claims cases and other civil cases. That's a huge savings to the system in terms of expense. These are part-time people that work for the court. And it will allow us to reach backlogs that we could otherwise not be able to reach. And then the last piece that I just want to mention, because it's a cross-branch innovation, has to do with our change in pretrial mechanism for minor motor vehicles that we're going to expand to other criminal cases. We now pre-try every minor motor vehicle case that comes into the court. And the effect of that is that we have saved tens of thousands of dollars for the state and local police and witness fees that they previously had to pay for their officers to come in to testify for trials that most often didn't happen. So the state police report to us that they have been able to cut their overtime budget in half. Local police are experiencing the exact same type of savings. And along the way, we have saved more than 100 judge days that we no longer have to schedule for minor motor vehicle cases, and has allowed us to free up those days to schedule those judges to hear other cases that do need to be heard by a judge. So let me end with that. Our commitment to change continues. We are also, along those lines, not afraid at any time to declare that we've made a huge mistake with one of our great innovations and turn the clock back and go in a different direction. It's all part of the change that we have become used to. So Many of you out there probably have your own stories of working with the courts, may have your own suggestions. We hope that you will, as Judge Netto said, pick up the phone, call us at any time. We're happy to speak with you and get some of your knowledge and perspective. So thank you all very much for being here today.
Good morning. I'm David King. I am the Deputy Administrative Judge of the Circuit Court, and what that means is that I get to go last. And so I had a number of things that I had jotted down to talk about, but I've checked most of them off, so I'll take Chris Keating's suggestion and be brief. If I could, I would like to go back just briefly, though, to the creation of the Circuit Court, which happened not that long ago. It was House Bill 609 that was introduced in late January of 2011 and took effect on July 1st, 2011. And just to give you the sort of the broad brush strokes of what we intended to do, there were two main goals in creating the Circuit Court. One was to allow us to constrict the management structure, which you've already heard about. We went from 52 managers down to 18, and thereby saved a significant amount of money in our management cost. The second piece of the Circuit Court was the expansion of judicial authority so that judges who were out there in the district, family, and probate courts could be certified to sit in other divisions. There's no mystery to the divisions. We have a district division, a probate division, and a family division. And when the bill was established, if you were a probate court judge, as I was, then you were automatically certified to be in the probate division. And then you need to establish competency to the satisfaction of the Supreme Court to be able to sit in the other divisions. So as Judge Delana said, now when I'm in Lancaster and I see Representative Moynihan, Attorney Moynihan in the North Country, he may be in the building in Lancaster on a family division case or a district case or a probate case, and now because I'm certified in all three divisions, I can sit on those three cases, and the clerk of that court, Terry Peterson, is the sole clerk in the First Circuit. Before the Circuit Court, we had 7 clerks in Colas County. Now we have 1. So not necessarily a fun job because there's still the same number of cases and the same number of divisions to schedule, but it's much easier for her to set her docket for the day. When I'm up there, as I was earlier this week, I think I had 1 probate case, a bunch of district division cases, and some family division cases, and the emergencies that come in all 3 divisions can be handled by 1 judge, where previously the clerk, as the chief said, would be on the phone trying to find a district court judge to travel to Lancaster, not everybody's first choice and destination, on a Friday afternoon to do an arraignment. So it's a much more efficient way to schedule our cases. I have the luxury of scheduling the judges in the Circuit Court. That's what you get, again, by being the deputy. We right now have 30 full-time judges, 21 part-time judges, and we have a number of vacancies. We have 9 full-time judicial vacancies in the Circuit Court. We don't schedule, as the Superior Court does, by county, where a judge will go to a county for a month. Bear in mind that we have 37 locations in 3 divisions. Not all judges are certified to sit in all divisions, so you can imagine the spreadsheet that we start with when we try to do the scheduling. And we have represented to you folks that given the current budget situation, we are going to decrease the number of judicial days down to 80% of our need. We have what we call a weighted caseload so that we know based on the volume of cases around the state how many judge days we need to cover those dockets, and we have reduced those days by 20%. So we need 12,715 judge days in 2013 to manage our docket, and we have scheduled 10,169 days. We've been able to fill those days with our full-time judges and our part-time judges, but I can tell you that if a judge gets sick or is out for an extended period of time, we're going to have trouble because we've pretty much maxed out our part-time judges. Judge Desjardins, for example, in the First Circuit, was the judge in the Colbert District Court, which sits about 30 days a year. He is now sitting more than 200 days a year because he's certified in the 3 divisions, and we move him around. But again, there's not a long list of judges signing up to go to the North Country, so something happened to Judge Desjardins where he was out, we're going to have to do some scrambling. The certification process, again, as I said, if you were already appointed in a division, you're automatically certified. In order to sit on other types of cases, you have to establish your competency. And we put the call out to our judges when the circuit court was created back in July of 2011, seeking people to sign up to sit in other divisions. And we had a lot of people that wanted to sit in the probate division, but it might come as no surprise that we had 0 people sign up to go into the family division. Not the thing that people get up in the morning wanting to do, go hear family disputes. It's tough work. We have the marital master program that's been in existence for a long time. Those were individuals who were doing the work because they wanted to. We're down to 6 marital masters at the present time. And so if you hear from your constituents that marital cases aren't moving as fast as they would like, that may be true. We've got a lot of innovations that we're working on to try to speed up that process and come up with ways to handle those dockets. So I think that's about all I have left to say that hasn't been said, so thank you very much for your time. It's been a pleasure to be here this morning.
Hi, I'm Chris Keating. I'm the new Executive Director of the Judicial Council, and I have the great misfortune of having taken over from a legend in New Hampshire government, Nina Gardner. She's in the back. She's performing the Vanna White role today, handing out the cards. While I'm on the issue of the cards, you all got cards. We're encouraging people to fill them out with any questions or suggestions or ideas for, in particular, the judges. And we will make certain that those questions get responded to individually, and so we'll be collecting them. Vanna will be collecting them afterwards in the back, so please take the time to fill out the cards. I spent 20 years as a public defender, 12 of the past years as the director of the public defender, and so I've been getting shellacked by judges for 20 years in my role as a public defender. So I come by this next comment honestly, I think, when I say, you know, because I have not always been the biggest fan. The judiciary that we have in this state is very impressive, and I think as a state we should be proud. The leaders in the judiciary right now run an institution that is nimble and responsive and has an eye on cost effectiveness, but never loses sight of the goal of achieving justice. And so I've been able to see its soft underbelly, and I really think that's the case. I think we're very lucky right now to have the leadership that we have in the courts right now. I'm no sycophant about the courts. You know, I run this independent state agency. I have 2 employees. We process bills for payment from providers. One of the most important things that this independent state agency does, the Judicial Council, is it funds indigent defense. And I'm going to say 15 seconds of information about indigent defense. Winston Churchill said that the mark and measure of the stored up strength of any society is a calm, dispassionate recognition of the rights of the accused, because they generally tend to be the most despised people in a particular society. And by that measure, I think New Hampshire stands head and shoulders above states in this country and countries in this world. We have an adequate, effective indigent defense system that provides representation to indigent criminal defendants and juvenile delinquents in over 27,000 cases each year. We do that primarily through a public defender program. We also contract with private attorneys, and we also pay assigned counsel attorneys to do that work, private attorneys. But the bulk of the work is done by the public defender program. We also provide services other than counsel, the expert forensic, psychiatric, investigative, transcript preparation services that are necessary to an adequate defense. The Judicial Council's primary responsibility is to oversee and to provide the appropriation, the funding that is appropriated by the state government for those important services. We also provide guardians ad litem to children who are alleged to be the victims of abuse and neglect, and we pay for the representation of people who, for guardians, for people who are facing involuntary commitment, civil commitment. The Judicial Council also plays an important ombudsman role, so it's a nice little pivot point. We've heard from the court, and now we're going to hear from members of the bar about access to justice issues. And so the Judicial Council, in its sort of ombudsman role, I think has historically played an important part in contributing to the discussions about how to improve the judiciary, how to improve access to justice in our state for people who need to use the courts to resolve the disputes and to try to make their lives better. We're joined today by people who've dedicated their careers to these access to justice issues, and so I'd like to turn the podium over to Richard Uchida and to John Tobin, who are going to speak about access to justice issues for the poor in New Hampshire.
Good morning. My name is Richard Uchida, as Chris said. I am not a judge. I'm a private lawyer with the law firm of Hinckley, Allen, and Snyder here in Concord. I usually practice business transactional law and real estate law. I live in Bow, New Hampshire, but I'm also the co-chair of the Supreme Court's Access to Justice Commission, which is why I'm in front of you. My role today is to tell you a little bit about the Access to Justice Commission. It's an all-volunteer commission that was created in 2006. In 2011, we received a reboot from help from the Chief Justice, and I co-chair that commission with Federal District Court Judge Joseph LaPlante, who sits here in Concord. The purpose of the commission is to expand access to and enhance quality of justice in civil legal areas, civil legal needs for New Hampshire residents. It's one of 27 commissions that have been created here in the United States. They're usually created by the Supreme Court of the state in which that court presides over. And so, as I said, we're one of 27. Most of these have sprung up in the last decade or so. We're made up in part by some members of the judiciary, but we're also made up by folks who are heads of the legal services providers here in New Hampshire. New Hampshire Legal Assistance John Tobin, who you'll hear from in a second, the New Hampshire Pro Bono Program, as well as the Legal Advice and Referral Center. We have Marty Sink from CASA, who is on our commission, Chris Keating from the Judicial Council, and members of the New Hampshire Bar Association and the Bar Foundation. But there are also many private lawyers on that commission who put in countless hours for the cause. So if you think of the judges that you just heard from who talk about the staff and the facilities and the courthouses and the electronic technology that can help so much in access to justice, our focus is sort of from the other side. We're focusing on your folks, on your constituents, and the users of the system. The Commission recently completed a legal needs study that was funded by the New Hampshire Bar Foundation. The research for that study was conducted by the Rockefeller Center for Public Policy at Dartmouth, and that study is going to roll out in about 3 weeks, but I'm going to give you a little bit of an advanced taste of that study because I think you'll find pieces of it remarkable. There are about 250,000 low-income people here in New Hampshire, and about 60% of them, about 150,000 of them, have legal needs on an annual basis. Of that 150,000 who have legal needs here in New Hampshire on an annual basis, we're able to serve about 8,500 of those folks, 6% or so. So the justice gap, the gap between the folks who need these services and the folks we're able to reach through all of the legal service providers here in New Hampshire is over 90%, and that compares to about 80% across the country. Who are these folks? They're women, disabled folks, senior citizens, recent immigrants to our state, and rural residents. The types of problems that they have are the ones that were illustrated by the court here: family law, housing, domestic violence, consumer areas, and benefits just to keep you alive or to get medication that you need. And the reasons that we're not able to do better in that gap right now is that we lack adequate service providers out there in terms of numbers. There are some physical access problems, but I think we're improving those. In some instances, it's just a lack of knowledge that there's a legal remedy that exists. There's an affordability issue, the ability to afford legal help in a problem. And in some instances, there's very little faith in the system. We're going to share some greater information for you as part of that legal needs study, as well as some possible solutions. But let me finish with this. For all of us, for you as the maker of the laws, for those of us who abide with great faith in the rule of law and the system of justice, this system doesn't work if it's not accessible, if it's not understood, or it's not navigable, or if it's not affordable. And if these problems persist, this promise of equal justice for all is a myth. Our job, our commission's job, is to close that justice gap you heard about and help fulfill that promise. So I want to thank you for your time today. I especially want to thank you for all that you do. And if there's anything we at the commission can do, I hope you'll reach out to us. Thanks. John.
Good morning. My name is John Tobin, and I'm the Executive Director of New Hampshire Legal Assistance, which is one of the civil legal aid providers, and I'm here to speak on behalf of all of them. Before I do that, though, I wanted to just say that I had the true privilege to serve on the Courts Innovation Commission a couple of years ago, and I can say, as Chris does from an outsider, that the court system has transformed itself into an innovative organization. Some people refer to that as a learning organization. This is a group of people who are trying to figure out ways to make the justice system work for all of us, and they are open to all kinds of new ideas, and they foster that. They push the lawyers in that way, and I am grateful for that, and we all should be. The civil legal aid system is three tiny ships, the Nina, the Pinta, and the Santa Maria. New Hampshire Legal Assistance is a statewide law firm. The Bar Association has a wonderful volunteer program, and you'll hear about that a little bit later, the Pro Bono program. That is a network of private lawyers like Richard Uchida who, in addition to their practices, take on cases for free for low-income people. It's one of the strongest and most active pro bono programs in the country. Again, something that New Hampshire should be proud of. The final piece of the three-part system is something called the Legal Advice and Referral Center. That is a call center for people who need legal help. When you came in today, you got one of these purple pamphlets, and I'd like to spend the rest of my time talking to you with the idea that our little legal aid system is a possible source of constituent service for the people who may be calling you about a range of legal problems and you don't know where to send them. As Richard has talked about, our resources are very small. The civil legal aid system is literally about 1/10 of the size of the criminal defense system. So we really have to triage. We cannot handle the boundary dispute or the name change or write wills or do a lot of the routine legal work for low-income people. We have to focus on the most urgent things. Housing, we handle foreclosures and evictions and property tax cases where someone's home is in jeopardy, mobile home park cases. In recent years, we've had a lot more foreclosure cases. We have some new funding to do that, the three programs together. We also handle what we call, and Richard mentioned, benefits cases, subsistence income and access to health care. Someone comes to us and their Social Security, their claim has been denied, or their benefits have been cut off, or they got a letter from Social Security saying that we made a mistake and sent you $20 a month too much for 10 years and you now owe us $10,000 and please send us a check. We handle a lot of those kinds of cases, and you will encounter constituents who are having trouble with some of those federal agencies. We also handle cases for people who are having trouble with state agencies, unemployment insurance, food stamps, Medicaid. The rules for all of those programs are complicated. The people who work in those agencies try really hard. They process massive numbers of cases, and sometimes people are denied unfairly. They need an advocate to help them. We try to do it as efficiently as possible. We use a lot of paralegals. We have really dedicated, talented people. People fight hard for our jobs. Even so, we don't pay them very well. And we also try to be innovative and creative. One of the things that we're doing that's mentioned in this pamphlet is we're now doing what we call online intake. A person who needs help doesn't have to try to get through on our phones, which are often clogged. They can go to the website, nhlegalaid.org, and start the process of trying to get legal help right away. I was initially somewhat skeptical of the ability of lots of low-income people to navigate this system. What we're finding is that many of them can. They get help from a relative or a child. They go to the library. I would encourage you to have people who need help start with that website. The choices we have to make every week about which cases to take are painful. They're really difficult cases. That's the hardest part of the job. We have a conference call every week where we have 20 or 25 cases. They're all urgent. People, and we have this in housing, in family law, in benefits. They're all urgent. We have to do triage to pick the ones where the client is especially going to be especially challenged to speak for herself or himself in court, where the legal issues are complicated, whether there's somebody on the other side who has a lawyer who's going to be very aggressive. Very, very difficult decisions. One of the things that we're seeing a lot of recently that we're trying to address for senior citizens is debt collection issues. There are some very aggressive debt buying companies and other actors, some of whom are in New Hampshire, some of whom aren't, who are pushing seniors to make payments and to make agreements with fear and harassment that are outrageous. And there are lots of seniors who live in fear of this and who need help from us. The final area that I haven't mentioned is the area of family law. And I think Judge Kelly did a really good job of talking about how challenging those cases are emotionally, how challenging they are for the court system to manage. In our programs, we are inundated with people who seek help with family law. We tend to focus our ability to work on those cases in cases involving domestic violence. And we have found that, in fact, one of the best things you can do for someone who's been a victim of that is get them a lawyer, because that gets them child support, the debt's straightened out, they can live independently and move on. But we don't have enough people to do that. Our funding is a patchwork of funding. We get United Way support, we get federal grants, we get wonderful support from the Bar Foundation. We have, until 2011, had gradually built up our support from this legislature. And as 2011 began, we had $1.7 million in funding from the legislature. The 2011 legislature cut $1 million out of that. And that meant that we had to lay off 14 people. It meant we had to close our Nashua office and our Littleton office. And all of that meant, and this is the important part, many hundreds of people with urgent cases have had to be turned away. So you've heard from a lot of us today. We have a justice system that I think is one of the most important things that government can do, to make sure that when people have disputes or they have urgent problems, you have a justice system that's innovative and responsive. I urge you to, in your roles as legislators, to take good care of that justice system. It's been a privilege to be here. Thank you very much.
Hi, good morning. Thank you for having me. My name is Jay Rancourt. I'm an attorney in Manchester. I work at the firm of Brennan, Karen, Lenehan, and Icapino. And I am the president-elect of the New Hampshire Bar Association. So I wanted to take a few minutes this morning to talk to you about the Bar Association, what it is and what it isn't. I know there have been in past years some misconceptions that the Bar Association works for the court system, and I'm here to tell you that that's not true. I think we work with the court system, but we are an organization that serves its members, those members being the attorneys. So we're called a unified bar association, and that means that all lawyers who practice in the state of New Hampshire are members of the New Hampshire Bar Association. So our full membership is over 7,000. About a third of those members have a primary office out of the state of New Hampshire, but practice law in the state of New Hampshire, and so they are a member of our bar as well. Essentially, what we do is after a lawyer is admitted by the New Hampshire Supreme Court, we take over the function of following up with those attorneys, of registration, basically requirement, who the attorneys are, where they're practicing, what they're doing, and we serve a lot of other administrative functions, such as monitoring CLE requirements and other things for our members. We are not, which is also a common misconception, the Professional Conduct Committee. We do not discipline attorneys. That is not part of the New Hampshire Bar Association. The Supreme Court Attorney Discipline Office handles discipline of attorneys. The New Hampshire Bar Association has very limited role in that. Our current sitting vice president sits on the Professional Conduct Committee, and that is our role in that committee. So what do? We basically serve three things. We serve the profession, the legal profession, and our members. We serve the public, and we serve the justice system. So let me tell you some of the ways in which we do that. First, I'll focus on the public, since that's your constituents for the most part. And John and Richard both touched on, the New Hampshire Bar Association has a pro bono program. We have over 300 attorneys in the state of New Hampshire that regularly volunteer their time to take cases for poor people in New Hampshire. And those are poor for their civil legal needs, not criminal defense needs. So what do? They do family law cases. We have had pro bono attorneys who have taken family law cases that have taken thousands of hours of time because the case has gone on for years and years and years, and the attorney sticks with it, gives up time where they could be billing or making money to try to help these poor people maneuver through the court system. They do some landlord-tenant. They do a tax program for low-income taxpayers. They do the foreclosure settlement, which they're working with NHLA and LARC on. They have done, I say pop-up things that come up. We received a call from a member of the military telling us that there was a deployment happening, and these members of the military needed living wills, powers of attorneys done now because they were being deployed within the week. And we were able to get volunteer attorneys to a location set up with computers and everything they needed to get these documents done for our military. So that's just one of the pieces of what we do for the public. We also have a DOVE project, which is part of our pro bono project, and that is the Domestic Violence Emergency Project. And those are, again, volunteer attorneys that help low-income individuals who need to get restraining orders against because they're being a victim of domestic violence. Our domestic violence program has served 2,600 victims of domestic violence since 1993. Last year, our pro bono program provided over 1,800 hours of legal services for the poor in the state of New Hampshire, all volunteer hours by our members. We have a reduced fee program that refers the public out to our members who are willing to take their cases on a reduced fee. We also provide for the public a lot of information about the legal system on our website. We have a part of our website is accessible for public, part of it is accessible only for members, but the part that is accessible to the public has a lot of information. So if you have constituents who call you with legal questions, you're not sure where to look, you can also look at our website. We have a law-related education program, such as a lawyer and judge in every school, if you've ever heard of that program, or our Project Citizen project, and that is designed to teach students K through 12 about the law, the legal system, and the fundamental principles upon which our democracy is based. We sponsor ongoing initiatives such as the Civics in Action program, which last year lawyers went to every Rotary in the state of New Hampshire and presented a basic civics program to all those Rotarians. We also have what's called a Public Protection Fund, and we administer that Public Protection Fund. The Bar Association does the administration of it. And basically that is if a citizen is harmed by a lawyer, such as a lawyer steals money from a client, and that client has no other remedy and has not been made whole in through any other forum, they can come to the Public Protection Fund and seek reimbursement for those funds which have been wrongly taken from them by a member of our bar. And so we monitor that as well. What we do for the profession is we do hundreds and hundreds of hours of continuing legal education programs for the profession. We provide ethics advisory services for our lawyers, which is not the same as a professional conduct committee, but if a lawyer has a question, they're not sure about an ethical boundary that they're challenged by, they can come to our ethics advisory committee and ask for an advisory opinion about whether or not what they're doing is ethical or how they should proceed in a sticky situation. We have activities for new lawyers just entering the profession, including mentoring programs and a lot of CLE and other programs. We also have a dispute resolution program for our members, which again is not the same as the PCC. They're not issues that would rise to the level of professional conduct, but maybe a dispute over a fee or a dispute over a portion of a file that the client thinks they should get back and the lawyer doesn't think they should get back, etc. They can come to this dispute resolution of the Bar Association and get a quick resolution and we try to serve both the public and our members by resolving those minor disputes. What we do for the justice system in general, we do some legislative monitoring and some limited advocacy. Because we are a unified bar, we typically don't take a lot of positions on legislation. We tend to try to provide information to you. We'd like to be here as a resource for you as you consider the implications of laws that come in front of you. If you need advice from a family law practitioner about a family law bill, come to us. We can put you in touch with those practitioners, the boots on the ground that see it every day. In any area of the law you have, you can come to us. We'll find somebody who can provide you information in that area. Unlike the New Hampshire Association for Justice, we tend not to take active lobbying positions on a lot of legislation, but we do sometimes take positions when we feel that the administration of justice is at issue. Then it is one of our mandates that we can take positions if our membership is overwhelmingly in support of the position that we're taking. We assist in the rules process with the court. We have a great relationship with the court. I said before, we don't work for the court, we work with the court. And just ask Judges Kelly and King as I call them and send them emails and say, one of our members told me that this was happening in this court and not in this court, and can we streamline, can we do that the same in both courts? So we have an ongoing relationship with the court, and we do try to make the process work better for everybody. We also support the work of the New Hampshire Bar Foundation. The New Hampshire Bar Foundation is the charitable arm of the New Hampshire Bar Association. It's a separate organization, but the New Hampshire Bar Association provides support services for the Bar Foundation. The Bar Foundation supported the funds for your breakfast this morning, so I'd like to thank the Bar Foundation for that. They also distribute funds to organizations that support law-related and civics education programs in the state. They administer the IOLTA program, which is the Interest on Lawyer Trust Accounts program, which provides funding for the civil legal services in the state of New Hampshire. So if you have other questions about what the Bar Association does or does not do, please feel free to contact me or the Bar Association. And thank you for giving me a few minutes this morning. Thanks.
Vanna, where are you? Fine. Well, I had been told earlier that questions were to be given in writing, but, you know, I don't care. If you want to just ask a question, that's fine with me. Representative Smith, how are you?
Recording, Walter, can you? Is
There
that
you
it?
go.
Now, okay. My name is Marjorie Smith, and I'm the chair of the House Judiciary Committee, and on behalf of the entire House, I would like to thank you very much for taking this time to come across the river to visit our branch of government and give us this information. There are some people here.
There's no place I would rather be this morning.
Well, thank you. And while we have a number of members here, others will take advantage of being able to pay attention to what you said from the convenience of their own computers.
Great.
I do have a couple of quick questions, and I'm not sure they're actually for you, Madam Chief Justice. They might either be for the Bar Association or others. The first is, I heard that there are about 7,500 lawyers, members of the Bar Association, which means there's 7,500 lawyers who are permitted to practice law in the state of New Hampshire. I heard that there are 300 lawyers who volunteer for pro bono, and last year they gave 1,800 hours of service. If I heard correctly, and if my mathematics work, we're talking about 300 out of 7,500, each giving an average of 6 hours. And I wonder, and I also heard that about 80% of the people who need legal services but cannot afford those legal services either at all or only at reduced rates are out there without being represented. And it occurs to me that there's a disconnect somewhere in who believes there's a responsibility to make sure that our legal system is accessible to all. Perhaps it might help if I knew where we ranked in terms of other states. Is that the usual practice in all states? Are there other states that are higher in terms of private attorneys taking responsibility? Are there other states where it's less?
Well, let me just offer a couple of comments and then ask President-elect Rancourt to fill in the details. We can't force anybody to work for nothing. We exhort people to volunteer, and if it's only 300, I'm grateful for every single one of them. Among those 7,000 plus lawyers is a large contingent of out-of-state people and a large contingent of inactive or retired folks who still maintain their membership, so the actual practicing number is much smaller, and I'm sure President-elect Rancourt can give you that data. But in an effort to try to ameliorate the problem of the disconnect between the people who would like to have a lawyer but can't afford one, the Supreme Court has done two noteworthy things, I think, over the past couple of years, and we're always looking for more. One is we amended our rules to create an aspirational goal of 30 pro bono hours per year for every lawyer. Now, as I said, we can't force people to work for nothing, but in the rules it says we expect you to find 30 hours in your professional life that you can devote to representing poor people or other kinds of public service efforts. And the other thing that we did was create a rule that allows for what's referred to as the unbundling of legal services. And the shorthand of that is that it used to be if a lawyer was in a case for a dime, the lawyer was in for the dollar. And there was no way you could extricate yourself easily from such a case. And that's a problem, because there are some cases that take on lives of their own and just suck lawyers dry. But we now have in place the possibility of a person hiring a lawyer for a piece of the case without any ethical implications for the lawyer. So the person can say, can you draft a document for me? Can you mediate a problem for me? Can you attend a hearing for me? And that can be done much more economically for the citizen. And as well, it provides the lawyer with some additional work. The lawyers would like to be professionally occupied at a living wage, but not all of them are, and this is one small step in that direction.
Thank you. I may have misspoke. I meant to say 18,000 hours last year, not 1,800. So if I said 1,800, that was my fault. It was 18,000 hours that were donated last year. But when I say the 300 number, it's actually a little bit over 300. Those are our active, regular pro bono attorneys who always volunteer, always have a pro bono case at any given time. There are other attorneys who come and go out of the system, and one year can take a pro bono case and the next year can't for whatever reason. We have about 2,500 attorneys who are active in the state and potentially eligible to take pro bono cases, so that takes out the out-of-state attorneys. We also have a government attorneys, public defender program can't take pro bono case, government attorneys can't take pro bono cases, and then there are the attorneys who just aren't qualified to take pro bono cases or don't feel qualified because they're transactional attorneys and they don't feel qualified to go into a family court. So it is something we try to improve. We actually have one of the highest volunteer pro bono rates of attorneys anywhere in the country. So although the number may seem small, in the United States, we have a very robust pro bono program, and our attorneys actually do a really good job of volunteering. They could always do better, and we're always encouraging it, but they do their best.
Sir?
Thank you, Your Honor. My name is Jim Belanger from Hollis. And,
Oh, hi, you're a neighbor.
and I'm a life member of DAV Chapter 7, which probably means only something to you.
Some of you might remember my husband. Once you've met him, you never forget it.
He is a character. 40 years ago, I was a bail commissioner in Hollis, and for violations, stop sign violations and speeding and so on, the police officers used to offer the defendant an option: go to court, or you can go see the bail commissioner, plead guilty or nolo, and sign a waiver for appearance. And I would go to court either every week, depending on the court date, or every other week, and turn in all the paperwork from the folks. To me, that reduced the workload on the court system, and for some reason that has ceased to be the case. I used to be provided by the court a list of offenses, speeding over so many miles per hour, and here's what the fine should be, and so on. So it was a no-brainer to administer this and then turn it into the court. It helped the defendant because they didn't have to appear in court to plead nolo. I understand that electronic filing now and so on may be changing some of that, but I think sometimes when we try to streamline the process, we cause ourselves more work. I would appreciate you looking into that and seeing if there's some of those things that could be reinstated at the local level, and it would help the court and help the defendants.
Representative Belanger, let me see if Judge Kelly has an answer for your question better than I can give, but I promise you we will look into it.
I've only been a judge for 27 years, so you predate my experience with the court. I'm not familiar with the system that you talk about, but today, in all minor motor vehicle cases, there is a system. It doesn't use the bail commissioner, but people respond directly to the Department of Motor Vehicles with their guilty or not guilty plea. Somewhere in the neighborhood of 80% of the cases, as I recall, plead guilty, send their fine to motor vehicles, so only that final 20% go to the court, which has been a streamlining. And then we've introduced the pretrial process to deal with those cases and whittled it down so that we're dealing with only 6% of the cases. Your question goes beyond motor vehicles, however. I think it suggests waivers in violation cases as well, and I appreciate that suggestion. That's something we certainly could take a look at.
It was a useful tool when my wife got caught for speeding, and she paid her fine. I didn't charge her the bail commissioner fee.
If you had, she would have taken it out of your hide.
Excuse me, can I ask from this side?
I'm sorry, I didn't see anybody over there, forgive me.
I've
Ma'am?
been wandering. Thank you. Donna Representative Schlackman. I have a question about the communication. It's great to hear about e-courts and things like that. I'm wondering if the communication between the small claims courts and the rest of the judicial and law enforcement system has improved. I've had an experience where you go to small claims court, you get a judgment, the person doesn't show up, there's a bench warrant. Then months later, that person shows up in another part of our system, gets arrested, even makes the news. You call the courts to say, so-and-so got arrested yesterday, can you enforce this bench warrant? And they say, no, we don't know where that person is. And it was explained to me that there's no communication even between our different county courts and the police and all that. And I'm wondering if our computerized communication has gotten to the point where if somebody's in one part of the system, whichever, and there are many, and they get picked up and involved in another part of the system, whether those two ever meet for justice to be served.
We're working on it. Some of you may have heard of a huge project referred to as J1. It has been a work in progress for about, 14 years now, give or take. Much of that work has been invisible all that time, but we have reached the point where the communication is actually beginning. I would like to let Judge Kelly tell you about what's on the ground now, what's coming in the next few months, and what ideas we're trying to float to try to ameliorate problems such as you suggest.
In the criminal area, Representative Schlackman, there is now visibility among all of the 240 or so law enforcement agencies in the state, so that if, for example, a bench warrant for arrest is issued by the Plymouth court, and that person is arrested in Nashua, when the officer signs into their system, it will appear on their system so that that person can be brought to the nearest court to respond to the warrant that's outstanding. I'm not convinced that a small claims warrant would be on the criminal registry, and there are probably very good reasons for that in terms of a civil case becoming criminalized by being part of the criminal information system.
And I think that's a missing point. It's great to hear that the other piece after 14 years is getting to a place where it really serves the public. But given the numbers that you described that do file small claims, and when somebody's been injured and the court agrees and there is a judgment and then there's absolutely no way to enforce that judgment, and then the other person enters the criminal system, you would think and you would hope that, at least now there's a chance for some restitution.
Right. We do have the ability internally, so within the court system, to know which person is scheduled in which court, but there's a little bit more work that needs to be done before we can get to the place where you're suggesting. But, you're raising a very common issue.
Okay. Well, thank you for the answer.
Representative Woodbury?
Thank you, Hunter. David Woodbury from New Boston. A few minutes ago, you noted the assistance of Northeast Delta Dental with the call center. That prompted me, along with the knowledge that we're debating the privatization of the correction system here in New Hampshire, to ask whether or not privatization of any services through the judicial branches in the offing for this newly emerging judiciary.
Haven't thought about that yet. I mean, it's not inconceivable that sometime in the future that might be something we would do, but frankly, we think that the judicial branch is a core function of government. It's in the Constitution, after all, and to me, at least, that means we're not going to outsource and privatize. I'm open to suggestions, and what we got from Delta Dental was training. They showed us how to do it, so we can do it ourselves, and I think much more efficiently and less expensively than we used to be doing it, which is not to say that there still aren't cheaper ways to do things going forward, so we'll keep an open mind.
Thank you.
Yes, Madam Chief Justice, I'm Bob Backus, and great to have you here. One of the
Thank
things
you.
you didn't touch on was the burgeoning world of private litigation through arbitration, funded by private parties. The court has long had a mediation program it's supported, and many lawyers have volunteered lots of time for that. And in addition, we have this tremendous growth of people taking their cases out of our court system and going to privately funded arbitration and mediation. What is the court system attitude toward that? Do you look on that as a good thing? Does it reduce your costs? And is that a good thing? Or are you worried that we're privatizing too much of our justice system?
Well, Representative, it's a very big problem because what it does over the long term is drain the development of the common law, because the civil cases that involve people who can afford to jump the line, so to speak, by hiring a private dispute resolution service are invisible to the law and to the notion of justice, and we can't ever see them or be certain as a society that people are actually being well served by that. They choose it, they get out of our queue, which is long because we don't have enough judges to move the cases through quickly. And while we're working on making sure our staff can process more cases with fewer people, that's still something we're not complete with, and I'm not sure what the ultimate numbers will be, but I can assure you your return on investment will be noteworthy. So I don't think it's a good idea, and what we've done to try to counter that is create an office of mediation and arbitration within the branch in an effort to expand those sorts of services across the branch, everywhere, in the circuit court and the superior court, to try to encourage those folks who would otherwise depart to stay with us and use our services in an effort to resolve their problems. And a few years ago, you know this, I'm sure, we created a business docket within the Superior Court that, if you're interested, Chief Justice Netto could tell you more about, but the idea behind it was to give a fast track to cases involving business disputes, companies with who knows what difficulties between them, so they didn't have to wait as long as they might otherwise have to wait behind all the criminal cases and so on. So we recognize it, we don't like it, and we're doing what little we can to try to ameliorate it.
Thank you, Madam Chief Justice. My name is Representative Chris Munns from Hampton. I was wondering if you could comment on the hours of operation of the courts. I will admit I haven't been following this closely, but I know last year there was an issue with courts not being open all the time. Could you comment on that?
I think we are, by virtue of the efficiencies that we have been working on over the past couple of years, I think we are back to the point where the clerk's offices are no longer closed to the public during the business day, which is typically 8:30 to 4:30. Am I right? The problem we had was that there was too much paper being pushed by too few people, and in an effort to get those orders out to the folks who were waiting for them, we closed the doors. But the call center has done a lot to help us. The off-hours processing has done a lot to help us, and therefore the doors are open. We also promised the legislature that we would no longer take furlough days to make sure that on all business days that aren't holidays, the courts are open during the year. There's a cost in that that's largely invisible, and it is that we have been unable to fill full-time judicial vacancies because there's an offset in the budget. But we are open during the workday throughout the state.
Thank you very much.
Thank you again for being here, and for all of you for your information today. I'm Jim Verschure, and I'm a newly minted representative from Dover, and so I'm learning things quickly.
You must know about that tree then.
I do know. In fact, I was the director of the Adult Learning Center, and Lily Ellison was my employee, so I know very well about the tree. And I'm very happy with the way it was handled. I put a sign actually in front of Lily Ellison's house when I was running for this position, and right by the tree. So one of the things I'm learning is, in spite of all the good things you've told us, there's apparently a fair amount of distrust of the courts. Yesterday, we spent more time than I wanted to spend dealing with petitions from citizens who were unhappy or felt they had been mistreated by the court system, or that their alternatives for justice had been shut off by the court system. I have no idea the validity of any of these cases, and as we said about the tree, there are two sides to every story, and in most cases we only heard the petitioner's side. But I guess I would appreciate understanding how much you know about that feeling in the legislature, and what your comments might be about the separation of the three branches of government, and what our role might be in redress of grievances, which I know was a hot topic last session, a redress of grievances from the legislature and its interaction with the court system. Thank you.
Okay. Here's the thing. The judicial branch does society's dirty work. There is nothing that happens in a courthouse on any given day that is not a problem for somebody to one degree or another, with the possible exception of adoptions. People smile on adoption day. When people feel aggrieved because their case didn't go the way they wanted it to, then very often that sense of grievance is aimed outward, and who do you blame? It's usually a family case. You might blame your spouse for being completely unreasonable, and he or she is doing the same about you. You might blame the court for not having done justice, and you might internalize your grievance to such a degree that you can't see that there might be another side to the story, or that, in fact, no injustice was done to you. We're not perfect. We are definitely not perfect. But my personal view is that that's what we're there for. We're there to resolve disputes between and among citizens, and you folks are here to make the laws by which we accomplish those results, which will generally not make everybody happy, and sometimes will make nobody happy, but that doesn't necessarily mean that injustice has been done. You know, if I win, it's justice. If I lose, I've been done wrong. That's a simplification. But I would urge any of you who is hearing these claims from folks to take the time and effort to go to the courthouse and look at the file, because you're only hearing one side of the story, and there is generally, I think, a lot to be learned from seeing just what the claims were and just what the results were in an objective sense. Now, if you do that and you leave the courthouse saying, oh yeah, I agree, my constituent was definitely done wrong, all right, that's what appeals courts are for. We're here to try to make sure that the law is followed and that the facts as applied to the law are not beyond the bounds of reason. That's our general function. But you probably won't be able to make your constituent either believe that or be happy about the results. yet you will probably have a better understanding of the other side of the tree, the marijuana plants, the other side of the story. Consider this. The judicial branch moves between 100 and 200,000 cases through its doors every single year. The numbers vary. Last year it was 120, something like that. It depends how you count. But out of all of those cases, last year were filed 26, I think, petitions for redress of grievance, of which fewer than 20 related to court cases about which people were unhappy. And I allow them their unhappiness, but I offer to you that if you're talking about 20 cases out of, in the family division, 25,000 cases per year, then I think by and large it can be said that we're doing a pretty fair job overall. And as I pointed out, we're not perfect, nor will we ever be, but I think those numbers are a little telling, and I once again would urge anybody who is being importuned along these lines to take the time to read the file.
Gary Richardson, and I want to thank you and the other speakers very much for being here. I think this has been very helpful today. My question, I think, probably is best directed to Judge Nadeau, and it just relates to the question of how long is the typical wait for a civil jury trial, and what is being done to try to speed up the process for civil jury trials?
Thank you very much. That's a great question. Let me first start by saying, we've talked about the judicial vacancies in the Superior Court. We're operating at about 70% of our weighted caseload need. We're at 18 right now. The statute authorizes 22. So we're doing the best we can to keep up with what the workload is. And we understand, we don't want to come here and whine about how hard it is to get the work done. We're trying to use this as an opportunity to create innovations and new ideas to get cases done. Generally, it depends on the county that you're in. For example, in Carroll County, there is one judge in that county, and his new filings per judge are about 800 a year, which is a lot. He works hard. If you then go to Nashua with 2 judges, their filings are 1,600 per judge per year. So they have twice the caseload that the judge in Carroll County does. So just that disparity tells me a lot about where do I need to focus my resources. In the civil arena, you hear the anecdotes every now and then in the paper about a case that's taken a long time to get to trial. It's really, the average is about 200 days from filing to disposition in civil cases. We try to take out the quick 30-day payment case so we can get a good snapshot of how long cases are taking. The couple of cases that were aberrations, when you actually looked at the file, you saw that there were many assented to motions to continue, not that we should be granting them all the time between the parties for various reasons. But still, 200 days, 250 days is a long time. So we are trying to use our mediation program. I have an attorney who's volunteered to help me look into the use of summary jury trials, which is sort of a quicker way of getting your case heard. If the lawyers agree that they don't need to have full-blown trials, they can make offers of proof, they can submit expert reports instead of having the experts come. Maybe they could get their trial done in 2 months. So a clerk of court in Stratford County and a lawyer in the Seacoast is working on putting a plan together for me to see if that can help with the backlog. I've also said to the clerks, even when we had to go down from 12 months to 8 months of jury trials, that doesn't necessarily mean that all criminal cases always get first in line on the docket. If you have an incarcerated felony, of course that has to go first. But if you have an unincarcerated, even felony, that has been on the docket for only 2 months and a civil jury trial that's been on the docket for 8 months or a year, that civil jury trial needs to go first. So I'm trying to get people out of the mentality that it automatically has to be a criminal case that goes first. We need to triage with all cases because of the importance of getting some of these civil jury trials done. So that's what we're working on now. Thank you for the question.
We strive every day to do a better job. Some days we succeed. Some days we fall back a little bit, but we keep trying. We're always available to you to answer your questions or to accept your suggestions. And I and my colleagues are all very grateful for the time you took to listen to us this morning. Thank you very much.
Thank you all for coming. Please give your suggestion cards to Nina Gardner, the Vanna White figure in the back, or to me. Thank you, Valenda Morissette from the Bar Association, for all your important help, and we're very grateful to Speaker Norelli for her hospitality in letting us use this chamber. Thank you.
as well?
Knock on wood, we're
Good.
healthy and she's working a 1,000-piece puzzle now.
Yeah. I haven't quite figured out what I'm going to do. I retired at the end of October, and so then we had the holidays, and then we had to, and so I'm just learning what it's like to be retired.
You and will take a while.
This
I'm
gardener.
still looking for a representative. Are you related to Janet? She's a representative.
No. I wish I could, but I'm not.
You know her?
I do know her. And I love her. You know, like everything was. Yeah. Good time to play. And he's a great guy. Hi. How are you? Good. I am. I am. When I turn around, you're about something else.
Yeah, people have said,
You know why I know I love it?
Did you really?
That day?
Yes. And
So it's the last thing she ever got?
and she wears it so, you know, and I thought it was one of the prettiest things they ever did. It is? Yep.
Sometimes you see something and you gotta have it.
Yep.
Birthday.
I know.
You'll never see that one.
Never. Never. You know.
I just got a new one of those, by the way, from Viking House, and it's a Norlander pink sweater. It's kind of a silver jacket, but it's like red and pink design. I was in, it's like a big
It's all right.
Harry bought it for me for Christmas. And
Well, Harry should buy it to you.
I was looking at it going, oh, this is kind of nice. I was surprised. I'm like, no way. So,
Nice.
I finally got it for her.
Yeah. Not today.
No,
They had a window open in there, 'cause, you know, it was so hot.
Yeah, it was not so heavy after the summer.
I mean, you know, the weather's gonna be cold.
I know. That's why
Yep.
By the way, pretty soon people will stop comparing you.
They really
It will stop. It really will stop.
2 decades. That's what I give them.
That's why I had to be back.
2 decades.
Mostly it'll take about a year. Right. And after about a year, everybody gets used to you being there, and then they stop, you know.
I stay away.
Collected $2 so far today.
Did you really?
But every time somebody tells you that you
Yeah.
have issues, you have to
I
pay
got
$1.
$1.
All right, I sent it to you at one point.
Great, thank you.
You know, and the work that was done on it. Well done.
Really?
Yes. But what I really appreciated. Yeah. Yeah, and it looks so good. It was really quite shabby. And they did a lot of it. Yeah, they did. And right, but at least it looks beautiful. Because the Senate chamber was always so. I mean, I think the Senate murals are just fabulous. And that's what we wanted to do it. The nice thing is, there is still this, you know, there's this grant through the Bar Foundation. There's Nina Doyle, executive director of the Bar Foundation, wrote the grant last minute, called me. I was chairman of the grants committee. And she said, okay, yeah.
That's nice.
On those things. And she was I was money.
Richard.
Until about 10 years ago. And then we lost the money. I got a grant It was 10 years ago. Yeah, it was 10 years ago. Richard, you were fabulous, you guys. It was supposed to be gone.